From the PEP Radio Newsroom, this is the hourly news blast. LGBTQ Nation is reporting a federal judge in Rhode Island handed four arts organizations a victory against the Trump administration in their challenge to the National Endowment for the Arts implementation of one of the president's anti-trans executive orders. In his September 19th decision, District Court Judge William E. Smith, a George W. Bush appointee, ruled that the National Endowment for the Arts' recent policy requiring all grant applicants to certify that federal funds shall not be used to promote gender ideology violates the First Amendment and the Administrative Procedure Act, according to Erin in the morning. President Donald Trump signed Executive Order 14168 on January 20th, the first day of his second term in office. The order claims to defend women's rights by declaring that the U.S. will only recognize two sexes, male and female, as determined by biology. Among its anti-trans provisions, the order requires all federal agencies, including the National Endowment for the Arts, to take all necessary steps as permitted by law to end the federal funding of what it terms gender ideology, the acknowledgement of the existence and rights of transgender and gender diverse Americans. As the Rhode Island Current reports, in response to the order, the NEA, or National Endowment for the Arts, added a compliance checkbox to its grant application in February, requiring applicants to certify that grant funds will not be used for projects that promote gender ideology. The following month, the American Civil Liberties Union filed a lawsuit against the National Endowment for the Arts on behalf of lead plaintiff Rhode Island Latino Arts and three other arts organizations that regularly produce LGBTQ plus work. The lawsuit argued that the policy violated the First Amendment, the APA, and the Fifth Amendment. As the Rhode Island Current notes, plaintiffs argued that the policy's language was unconstitutionally vague as it did not define what constituted promotion of gender ideology. They said the policy targeted a specific viewpoint would result in organizations either being denied funding or adjusting their First Amendment protected speech. As Erin in the morning reports in his decision, Smith sided with the arts organizations on the first two counts. Smith ruled that the National Endowment for the Arts policy of considering whether projects promote gender ideology in its grant approval process violates the First Amendment because it is a viewpoint-based restriction on private speech. Additionally, the policy, which grants National Endowment for the Arts chairperson sole authority to implement Trump's anti-trans order, violates the APA by exceeding the National Endowment for the Arts chairperson's authority under the NEA's authorizing statute by its arbitrary and capricious nature. There is zero explanation of what it means for a project to, quote, promote gender ideology, end quote, let alone how that concept relates to artistic merit, artistic excellence, general standards of decency, or respect for the diverse beliefs and values of the American public, Smith wrote. In short, the National Endowment for the Arts has made no effort to justify its policy on any grounds aside from complying with the executive order. However, Smith rejected the plaintiff's argument that the National Endowment for the Arts policy was unconstitutionally vague under the Fifth Amendment. Smith's ruling vacates and sets aside the NEA's policy and permanently enjoins the agency from implementing a viewpoint-based standard of review that disfavors applications deemed to promote gender ideology and from requiring arts organizations to comply with Trump's anti-executive order when using National Endowment for the Arts grant funds. In a statement, Rhode Island Latino Arts Executive Director Marta V. Martinez said that the decision affirms what we have always believed: the freedom to create, to express one's truth, and to tell our stories is a right protected by the First Amendment. As an organization deeply rooted in storytelling, theater, and the preservation of cultural history, we are relieved and grateful that the courts have recognized the importance of protecting artistic expression for all people, including those in LGBTQ plus communities, Martinez said. Vera Eidelman, senior staff attorney with the ACLU's Speech, Privacy, and Technology Project, said the ruling marked an important victory for freedom of speech and artistic freedom. At a time when the government is using its full weight to try to impose ideological conformity. This order is an important reminder that the First Amendment protects us from exactly that, Edelman said in a statement. Even when the government funds private speech, it does not get to support only those messages that parrot its views. That's the news blast at this hour. Up next, we have the Meadville area weather forecast here on PEP Radio.